Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. And I'm going to talk today about non-compete agreements in the recruiting and staffing industry. Sometimes I think it is really useful to break things down on an industry-specific basis. And let me tell you why I say that. I have reviewed hundreds of non-compete agreements. I've litigated numerous non-compete cases, and I have resolved in excess of 200 non-compete disputes out of court over the past several years. These disputes have come out of every industry imaginable. I have done a great deal of work in the broader healthcare space, and this involves everything from doctors fighting over patients, medical practices breaking up, pharmaceuticals, medical gas sales, medical equipment sales, medical technology development. I've done a great deal of work in the tech and software space, everything from the development of some type of new robotic technology to the development of software to website development. And then I have done a great deal of work with sales broadly in any particular industry, from pharmaceutical sales to nutritional supplement sales to widget sales. So I have a very broad perspective on different industries and non-compete litigation within those industries. Now, for the most part, the disputes that I've handled and the cases that I have litigated involve Florida choice of law because I'm located in Florida. But I have resolved a number of non-compete disputes that called for another state's law. I've handled non-compete cases under New York law, Virginia law, Mississippi law, Indiana law, Illinois law, and the list goes on and on. So I have a very broad national perspective on trends in non-compete litigation. And I have a broad industry perspective on non-compete litigation. And that gives rise to today's topic, which is the industry-specific discussion of non-compete agreements in the staffing and recruiting industry. You want my bottom line? My bottom line is that 9 times out of 10, non-compete agreements in the recruiting and staffing industry should be unenforceable. Put a fork in them, they're basically done. Obviously, there are some caveats, there are exceptions, and I will address those at the end of this discussion. But first, let's get into the mix and let's talk about why they're unenforceable. Hypotheticals always make life so much easier. We're going to take a hypothetical, we're going to draw it from an actual case. I might get some of the facts a little bit off, but you're going to get the basic story. You have 2 staffing companies. One of them is called KForce and one of them is called Beacon Hill. You have a gentleman named Jim. Jim works for KForce. He handles several accounts that he is given. Among those accounts are 2 companies. One is called Charter and one is called Hospital Corporation of America. These are both multi-billion-dollar companies publicly traded on either the NYSE or the NASDAQ. These are big players. They have lots of positions to fill. So Jim works at KForce. He handles these accounts. He has dealings with the account managers. He worked in the industry previously for another staffing company, and he knew some folks at these companies before he came over to KForce. So he works for KForce for a couple years, and then he gives the notice that he's going to resign. Before he resigns, he emails himself some outstanding positions that KForce is seeking to fill for these 2 companies, Charter and HCA. Then he quits. Last day on the job, walks away. The next day, he starts at Beacon Hill, and he immediately begins going after those same companies, Charter and HCA. He aggressively reaches out to the hiring managers. He says, guys, I'm at Beacon Hill now. I want to win your business. Make sure you keep me on your email list when you're sending out announcements about new job positions, etc. So, as always happens, someone at KForce gets wind of the fact that Jim is now at Beacon Hill and that he's going after these same customers and these same accounts. KForce sues and says, this is a breach of Jim's non-compete agreement. We're facing irreparable harm. We want an injunction. how does this go down on the law, and why do I say put a fork in it? Why do I say it's unenforceable? There's no legitimate business interest here, folks, okay? Number one, the biggest two legitimate business interests that you hear, 1 and 2, confidential information and customer relationships. Sure, there are other legitimate business interests that you can bring out in non-compete litigation, but the two big ticket items are almost invariably confidential information and customer relationships, and you don't have those in this type of hypothetical. Let's start with the confidential information. In the hypothetical, and as in the actual case that was recently litigated, KForce says he has our confidential information. He had access to it when he worked for us at KForce, and he emailed it to himself before he left the company and went to work for Beacon Hill. He emailed himself the names of hiring managers, the names of contacts at these customers, the job descriptions for open positions that they were trying to fill right now, organizational charts for these companies, etc. Is that confidential? No, none of that's confidential. The name, in the modern world, the name of the hiring manager, one of the many hiring managers at a massive company like Charter or like HCA, that person's name is not confidential. You can easily go on LinkedIn, do some due diligence, and find that person. Further, there are a litany of subscription services that recruiting and staffing agencies subscribe to, where they are provided lists of these hiring managers, organizational charts, the whole 9 yards. So number one, none of this stuff is confidential. And maybe you have a sort of bad actor issue from a standpoint that Jim emailed this stuff to himself and was, trying to take this stuff when he left the company and do something unfair, but that doesn't convert public information into confidential information. So number one, you have no confidential information. And in fact, in many instances, the non-compete agreement, the employment agreement, will actually contain a provision that says employee recognizes and warrants that he has been given access to the company's confidential and proprietary information such as blah, 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 blah. That's nonsense. The mere fact that an employment agreement, that a contract says an employee has been given access to confidential information, likewise, that cannot transform non-public, non-proprietary information into confidential information. It doesn't work that way. In Latin, it's called an ipse-dixit. Your ipse-dixit assertion that it's confidential does not make it so. That's not how it works. So, no confidential information. That's completely off the table. Now let's look at the customer relationships. Again, a lot of people are confused about customer relationships. Yes, you can protect some customer relationships through non-compete agreements, but you cannot protect all customer relationships. In Florida, under Florida terminology, we refer to the protectable relationships as substantial customer relationships. A special customer relationship is protectable. From my perspective, when you're in an industry where there's fierce competition, everything is public, people are vigorously competing to win the work, to win the project, to win the job, you're unlikely to have substantial or protectable customer relationships. And you see that play out in the staffing industry context. And in this case, in our hypothetical involving KForce and Beacon Hill, let's go back to that. So KForce says these companies, these customers who we were trying to fill positions for, these are protectable relationships, and that's why this person should be enjoined. That's why Beacon should be enjoined. That's why we have damages. Let's take a closer look at that. The customers themselves, Charter and HCA, they're not exclusively working with KForce. In fact, the record in many of these staffing and recruiting cases, and I've resolved certain disputes in this industry as well, and I've reviewed a number of non-compete agreements in this industry. And it appears to me that the usual protocol is a big company like a Charter, like an HCA, blasts this position to everybody and their mother. So the hiring manager at HCA sends out an email to 20 or 30 staffing agencies and says, we need an IT manager. Go and get me some candidates. And then whatever company comes up with the best candidate, they win. So in this context, in the staffing and recruiting context, you are unlikely to see substantial or protectable customer relationships. The decision in terms of where to buy, and in this context, buy means which staffing agency to pay, that decision is not bound up with customer goodwill or with a customer relationship with a particular vendor. It's not bound up with that at all. It's entirely based upon who can produce the best candidate. Nobody at HCA, nobody at Charter is saying, well, KForce or Beacon Hill, we like your staffing agency better. We don't like the client you brought us or the candidate you brought us as much as we like the one over there, but we're going to hire the guy you brought us just to do you a solid. Nobody's saying that. That's absurd. This is a fiercely competitive industry. By and large, these positions are not being filled on an exclusive basis. Numerous staffing companies are in the mix for the work. They're vying for it fiercely. Those customer relationships are not protectable. And in fact, in the recent case where this issue was litigated involving KForce and Beacon, where KForce took the position that they were protectable, the court said nonsense, it's hogwash. There are emails in the record where the account manager at the company, at the client, at the target, at Charter, at HCA, is blasting it out to 20 or 30 staffing agencies saying, fill this position. So the customer relationships are not protectable. The upshot then is, if you don't have confidential information, if you don't have protectable customer relationships, and you don't have any other interest there, you have no legitimate business interest, and therefore you have no basis to enforce a non-compete agreement. A lot of people get it twisted, where they think that just because a non-compete agreement exists in writing, that it's automatically going to be enforced. Oh, you signed this contract. Nonsense. Non-compete agreements are restraints of trade. Before a lot of these things were codified in state non-compete or state antitrust statutes, that's what you're looking at, antitrust. So these things have to be scrutinized. And if you have no legitimate business interest, it's unenforceable. And in the staffing and recruiting context, I believe 90% of the non-compete agreements are likely unenforceable and easily subject to challenge. Now for the caveats. Number one, if it's an exclusive position, for instance, say an elite staffing company, say McKinsey or whatever it is, Major Lindsay or whatever, let's say that staffing company is recruited to find the next college president of such and such a college, or to find, the general counsel for a major Fortune 500 company, and it's an exclusive agreement for them to be the exclusive company working on sourcing the candidate. That's a much different ballgame. If a recruiter in that context is working on an exclusive deal, jumps ship, takes that exclusive with him, and then fills it at his new company and they get a big commission, that's a different ballgame. In that instance, there would be a legitimate business interest because you probably have both, right? Confidential information from a standpoint that the position is probably confidential. It's probably not been publicly announced if it's an exclusive. So that's confidential information. And then two, you would have the customer relationship because it was an exclusive relationship. It wasn't sort of put out to bid to everybody and their mother. So that's caveat number one. Caveat number two, somebody who is high up the food chain in a staffing and recruiting agency. So people who are actually doing the recruiting, 90% probably not so much in terms of enforceability. But say you have somebody who's the vice president, the CEO, etc., and they've been privy to a great deal of corporate secrets, strategy, long-term projections, financials, etc., then you arguably would have confidential information, and there it would likely be enforceable as well. Jonathan Pollard, non-compete and trade secret attorney in Fort Lauderdale, Florida. Man, I love this stuff. If you have a question about a staffing agency non-compete agreement or any non-compete agreement, please feel free to call my office. I'd be happy to talk. Thanks for watching. Have a good day.